Okay, got a question about if a fridge breaks, is the landlord responsible for the repair costs? And this is in response to the video about the new requirements that will from the habitability standards under Civil Code Section 1941.1. Hi, my name is Rob Wells. I'm the Landlord Warrior on TikTok and YouTube. Please feel free to like, share, and subscribe to our videos. Now, you may have heard that there is the new habitability standards going into effect January 1, 2026. Regarding most landlords now are going to have to provide operable refrigerator and stove now. And this question was directed towards if the landlord is responsible for the repair costs of the refrigerator. Okay, so the new rules are if the tenant opts to bring their own refrigerator to the property, right? If the landlord has certain disclosures in the lease that advise the tenants of their rights to a refrigerator, and the tenant brings their own refrigerator, despite that, the landlord is not responsible for repairing the tenant's refrigerator. In fact, that disclosure states that the tenant will be responsible for maintaining their own refrigerator if it breaks down or if it needs repairs. Okay. That being said, if it's a landlord provided refrigerator or the tenant opts for the landlord to provide a refrigerator, because the tenant can give notice to the landlord and within 30 days, the landlord has to provide the fridge, the landlord's going to be responsible for the repair costs. If the refrigerator breaks down, it's just normal wear and tear, the tenant didn't do anything wrong using the refrigerator. Okay, so under normal circumstances, yeah, landlords are going to be responsible for fixing that. However, I know there's going to be people that are going to say like, hey Rob, what if the tenant intentionally broke the refrigerator or misused it and broke it? Well, in that case, then the law has always been if the tenant has caused the damage to the appliance or whatnot, they would be responsible for reimbursing the landlord for costs. So many good leases, what would have to happen is the landlord would make sure that refrigerator is repaired, bear the expense, and then in many good leases, demand that the tenant reimburse the landlord. And in many leases, the good ones, it will put, if the tenant causes some repair, reimbursement is due upon demand, basically. And if the tenant fails to pay that demand, the landlord technically could issue a 3-day notice to perform, advising the tenant, hey, listen, per the terms of the lease, you caused the damage, basically, you got to pay for it. Okay. And in that case, you would want to have clear documentation like that this was like misuse, like someone slammed the door and the door fell off or something. It was all bent, that type of deal, as an example. Okay. Now your mileage is going to vary. Facts are going to differ, from case to case. So if landlords, if you're contemplating, do I have to repair this or not? Did the tenant broke it? Is it an actionable thing that I can ask for reimbursement for? Best to talk with landlord's counsel or your attorney to figure out the factual circumstances. My general rule is, with a habitability item, landlords get it fixed ASAP, as soon as practical, basically. And if there are damages, usually that could be framed as a lease violation, and a demand for reimbursement could be made to the tenant. So landlords in the Northern California area, if you need help with this, feel free to reach out. You can hit our profile below, it takes you to our website. You can book a free case review. A couple of questions on the website that will ask it, that will be asked to see if we're a good fit or not. Put your comments, questions down below. Until next time, folks, I'll talk to you then. Thanks.